Our next speaker, perhaps in fairness to the Crown now, when His Honor Judge Grayburn was introduced earlier in the program in the first week, it was mentioned that he had been the Crown Attorney of the Judicial District of York, and when appointed to the County Court, some people thought he continued in his former role. Well, our next speaker, prior to his appointment, was President of the Criminal Lawyers Association, and there are some Crowns that have felt that shortly after his appointment, he continued in his former role. Our next speaker, with respect to summary conviction appeals, His Honor Judge Whealy.
I've chosen for the title of my remarks tonight a jaundiced view of summary conviction appeals. I shall shortly prove to you that county court judges are in a class by themselves in their enthusiasm concerning summary conviction appeals. It is, from their point of view, an unfortunate accident of legislation of long standing which imposes this inescapable appellate jurisdiction. The High Court is selected by the legislation, if you look at Part 24, to deal with appeals where the issue is one of pure law, there being no facts in dispute, by appeals by stated case. The Provincial Court Criminal Division is selected to be the trial court, and more particularly, that is the tribunal that decides what the facts are. What is carved out as the role of the county court judge is the jurisdiction to decide appeals in which, presumably, the issues are of mixed fact and law, but where the judge is, with rare exception, bound by the facts determined by the trial judge. And of course, sentence appeals, which the legislation chose not to entrust to a high court judge, since he is only a judge of a court of a superior jurisdiction. Before the amendments of 1977, the county court judge's jurisdiction was really quite simple. He held a new trial when a summary conviction appeal arrived before him, made his own findings of fact and law, and if sentence was also appealed, then decided an appropriate sentence. All of this was done without reference to the original trial and without any concern whether that trial was properly conducted or not. The amendments of 1977, I think, were intended to reduce the number of appeals by eliminating those where the appellant simply disliked the result obtained at the provincial court trial and decided to have another shot at it, as well as reducing the time which such appeals occupied by forcing specific grounds to be articulated which allege some error by the provincial trial court, but without permitting a new trial. A companion piece of legislation by the province removed from the county court appeals arising under the Provincial Offences Act. And I must say that I am unaware of any county court judge who laments the passage of that act. The appellate jurisdiction remaining to the county court is, in my view, not readily defined, and furthermore, it is not readily understood by many lawyers or the public. Perhaps any radical surgery requires some time for acceptance and recuperation, and perhaps 4 years is as yet insufficient for these amendments and their implications to have settled into common knowledge. One of the principal problems, in my view, is that the vast majority of summary appeals are brought to the county court by unrepresented appellants who, quite rightly, feel that the cost of retaining counsel is far too great by comparison to the sentence or issue being appealed. Yet the new appellate procedures are more cumbersome and more technical in many ways than the old. Consider the summary conviction appeal rules. The contents of prescribed forms, periods in which to make service, who must be served, etc., all make strange reading to a layman, and our rules aren't even found in the criminal code because they're peculiar to Ontario. It seems to me that while the idea behind the amendments may have been well conceived, the methodology adopted in practice makes the availability of the right of appeal to the layman too onerous and thus denies him what he thinks are his rights. It is much easier to launch a prisoner's appeal in a court of appeal for a conviction for murder than to launch a summary conviction appeal in the county court for common assault. My remarks are not intended to suggest that the county court cannot hear appeals which involve only a question of pure law. Indeed, it very often does hear such appeals. Further, I believe that appeals by way of stated case are relatively rare. My point in these comments is to suggest that the scheme of the legislation is as I have put it, but the lawyers and the public are very quick to see which is the less costly way, as between a stated case or otherwise, and hence the overwhelming majority of appeals are under Section 748 to our code, much to our chagrin and our loftier brothers' delight. And yet the deadly truth is that this type of work involves about 80% of the public's individual contact with our system of justice, and so our system is probably judged by the public on the basis of their experience in these cases. Now let us take a brief look at both methods of summary conviction appeals. Appeals by stated case. And this is a situation where the procedure is laid out in the code and not by way of rules passed under the code peculiar to the province. And they're found in sections 761 to 770. The court hearing the appeal is defined as the Superior Court, which by definition, under subsection 2 of the code, is the Supreme Court of Ontario High Court. The appeal is commenced by applying to the summary conviction court to state a case, not by serving anything on anybody else. There are only two possible grounds: error of law and excess of jurisdiction. Now, when you're talking about error of law, let me give you a couple of examples of where you may fall into some trouble. And I'm using only the current edition of Martin's to assist me. For instance, where a charge under a municipal bylaw is dismissed on the ground that the bylaw is invalid, that's a proper subject for an appeal by way of stated case and not an appropriate subject matter for a mandamus. But if the judge finds that the information upon which such a prosecution is laid to be a nullity, then it's not a proper case for a stated case appeal. The proper remedy is mandamus. Now, if the information is quashed upon the objection taken prior to plea that there has been a failure to comply with the requirements of Section 510, which you'll recall is incorporated into Part 24 and is the bare minimum that must be in an information to establish a charge, then that failure is a proper subject for a summary conviction appeal by way of stated case. But there is no appeal under the same procedure where the information is dismissed for failure of the Crown to supply particulars ordered. Now, if that makes sense to you as lawyers, and perhaps it does, I can assure you it doesn't make much sense to a layman. I won't talk about excess of jurisdiction because, frankly, I don't see the distinction between that and an error of law. Now, the right of appeal is confined to the Attorney General or a party to the summary conviction court proceedings or their counsel or the Attorney General's agent. The right of appeal is confined to the subject matter. The following words are important: a conviction, an order, a determination, or other proceeding of a summary conviction court. And I'll come back to that in a moment. Subject to the rules of court, it says in the code, and there are none in Ontario, the application shall be addressed to the summary conviction court and be written, served upon the summary conviction court by, quote, leaving it with that court. And I'll come back to that. And to be done within 30 days of the adjudication under appeal. The summary conviction court shall state the case, quote, within 1 month. So you make your application within 30 days, but that court may have 28 or 30 or 31 days, depending on what month you decide to leave the application with it. Now, let us be quite fair. The summary conviction court does not take a blank piece of paper and state the case. Counsel draft the case and submit it to the trial judge. Now, in most cases, the respondent is brought into it either by the judge to make sure that he doesn't agree with the summary of facts and so on that the appellant counsel has drafted, and there is often, in my experience, quarrels over how it shall be stated, and therefore the 1 month period that is referred to in the code is not exactly generous. Now, there is a little bit of conflict in other provinces about who has the right to the final word in settling these arguments. In one case, Regina and Tar, which is quoted in Martin's Criminal Code, so I won't bore you with the citation, it is stated, the first section of the stated case, setting out the facts found at trial, is a sole province of the judge, and he may rewrite the draft submitted to him by the appellant. But the second section, setting out the grounds upon which the proceedings are questioned, and the third section, propounding the questions, are both the sole prerogative of the appellant. Now, Regina and Tar was decided in the Supreme Court of British Columbia. In Regina versus Windles, which is found in the same paragraph in Martin's, the stated case is that of the summary conviction court and not the appellant, and thus should be in a form acceptable to that court. In Ontario, I don't know of any case that deals with that particular subject, but I suggest to you that you will have very little difficulty if you have the respondent there getting the judge to agree basically with any agreement between you, and he won't have much trouble making up his mind if there's no agreement between you. Finally, that stated case must be signed in person by the summary conviction court, and then another set of time periods run. Within 15 clear days, not 15 days, not 1 month, not 30 days, but 15 clear days, the appellant shall give, and that's the word, written notice and a copy to the respondent, transmit, and that's the appropriate word, the stated case to the Supreme Court of Ontario. Now, I am a bit at a loss to understand why, and these are not new words. When you leave with the court the original application and you give written notice to the respondent and you transmit the stated case to the Supreme Court of Ontario, whether the draftsman was exercising literary talent or sheer ignorance. But he should have known that the legal profession will always find a way to argue about something, and those 3 words in those 3 separate situations have given rise to probably 100 different decisions. In any case, in practice, as long as you get it to the appropriate person, you don't run a problem. The interim release provisions of Section 752 and 752.1, which are involved in county court appeals, apply in stated case appeals. 757 is also applicable, and that, in a sense, permits the Supreme Court of Ontario to dismiss the appeal if the accused has breached his release conditions. It's not a question of punishing him for the breach. It's not a question of fining him or punishing him for contempt. Out goes the appeal itself. 765 deals with frivolous applications to state a case, and while the summary conviction court may refuse, it must issue a certificate of refusal, except in the case where the Attorney General is the applicant. Then 766 provides something that the layman is sure to be very familiar with. It provides an appeal to the Supreme Court of Ontario from the issuance of a certificate of refusal. Now, I really wonder how a citizen is supposed to cope with that if he is also confined to jail and hasn't been able to raise any bail. But in any case, that right is available to him. And when he decides to make use of it, he must serve the respondent, he must get an appointment from the Supreme Court of Ontario, and he must serve the summary conviction court. Now, the result of that appeal is, of course, that the Supreme Court of Ontario judge who hears it may order the summary conviction court to state a case, and if so, the criminal code commands the trial court judge to do so. Section 768 sets out the power of the Supreme Court on the merits. It may affirm, reverse, or substitute its own order. Really, that amounts to a complete discretion, and properly so. It may send the case back to be amended, and then hear the appeal on the merits. Or it may send the matter back to the summary conviction court for it to deal with, together with the opinion of the Supreme Court judge. There is a provision for costs, which, according to my information, is almost never used. And finally, it is provided that the Supreme Court judge may deal with an appeal of this nature in court or in chamber or during the vacation time. Now, there are two other sections that deal with enforcements, but they really don't help us. What is emphatically clear from the 10 sections is that it provides a mechanism for an appellate determination of a point of pure law where no question of or issue of fact is permitted to be considered. And it is drafted upon the presumption that either a civilian genius or a lawyer will be involved. It is worthy of notice that a further appeal lies to the Ontario Court of Appeal upon leave being given on a question of law alone, and then the Supreme Court Act provides for an appeal to that court. Now, all said, what if the appellant really is in jail? How can that person, in all reasonableness, assert his right to appeal by way of stated case? Legal aid may help, but it cannot respond reasonably within the limitation periods, nor serve, give, transmit, or leave with documents as contemplated by the procedure. The machinery of this kind of appeal is geared solely, of appeals, summary conviction appeals, is really geared solely to a 784 appeal, which I'm about to deal with, and not a 761 appeal. Yet the latter may be a good deal more appropriate and more authoritative. Well then, let me leave that and get on with the appeals that come to our court. Section 747 provides that appeals from a summary criminal court shall be to the local county court. Now, I use the word criminal in the constitutional sense. That is, any summary conviction offense or any non-indictable offense created by the Parliament of Canada or derived under a statute. Now, I must tell you that there are literally thousands of them. Airport parking violations, fisheries regulations, pesticide control, the Dead Meat Act, the Fruit, Vegetables, and Honey Act, just to name a few of the more common ones. Most prosecutions under the Income Tax Act, the Excise Act, or the Federal Sales Act, the Tax Act. Certain narcotics and food and drug offenses. And don't think now of Part 3 or 4 offenses under the Food and Drugs Act. Think of all of the hundreds and hundreds of regulations there are under the Food and Drugs Act dealing with the way hospitals, doctors, pharmacists, and manufacturers deal with drugs, how they're stored, what records they must keep, et cetera, et cetera, et cetera. Each one of these requirements, by virtue of a final paragraph in those regulations, can constitute an offense. All such federal summary conviction offenses are tried, of course, in the first instance by a justice of the peace or a provincial court criminal division judge exercising the power of a magistrate. From such decision or order, an appeal lies to the county court from, now here we are, a conviction, order, sentence, or a dismissal. Now, would you compare that, please, with what may be the subject of a stated case appeal? A conviction and an order are the only two words in common. In an appeal to us, it includes sentence or a dismissal, but the Supreme Court, in a stated case appeal, can deal with a determination or other proceeding. Well, I would have thought that perhaps other proceedings might include a sentence or a dismissal, but I am told that that's not the case. I don't propose to go through the cases that persuaded me of that, because maybe you can persuade someone else that they're wrong. But in any case, if you were a layman, would you know any distinction between those words? And if you could, would you know which was the procedure that is most important to you, appropriate for you? The right of appeal lies in the defendant, the informant, or the Attorney General of Ontario or Canada, or their agents. The word agent is not defined, and in the context of Section 748, only the informant or the appropriate attorney general may appear by agent. The defendant must appear personally or by counsel. There's a case on that subject, Regina versus Hammond. The process of appeal begins with a notice of appeal, but its content, its manner of service, the time limits, and so on are all specified in the rules of court of each province. Although, with one exception, Section 750 of the Code specifically permits extensions of time in matters which is, when the Act was passed, it didn't know what the time limits were. For Ontario, the summary conviction appeal rules may be found in the Ontario Annual Practice, which is often referred to as CHITTIES. Now, I do not propose to set down every detail of procedure. You're well able to read the rules by yourselves. What is important to note is that the elements of the procedure are different if the Crown appeals or if the convicted person appeals. Briefly, the contents of the notice of appeal are set out in Rule 2, and the filing and service requirements are set out in Rule 3, and herein lies the first procedural difference. If the convicted person appeals, it is enough to serve the notice in the clerk of the court and by registered mail upon the Crown within 30 days. However, if the Crown is the appellant, service upon the respondent person must be personal or substitutional upon a judge's order. Thus, the procedure allows the citizen to serve the institution of government, whereas the institution of government must find and serve the citizen personally. The procedure for bringing up the trial record is semi-automatic. Upon service by the citizen upon the appellate court clerk, responsibility on the citizen ends so far as moving trial records and exhibits to our court. All the citizen must do is order a transcript and file a certificate from the court reporter with our court clerk within the appropriate appeal period. Thereafter, the rules provide that all the procedures move automatically until a mailed notice of appeal hearing is sent to the citizen. Except may I remind you that the law knows nothing of mailed notices of appeal. The law says that the appellant must look in the court clerk's notice board. So that is a point to watch. If the Crown appeals, of course, as I mentioned, it must affect personal service or get a substitutional service order from a judge. And of course, that judge must be an appellate court judge or a county court judge. One notable exception to the foregoing overview that I've given you is the matter of bail or security. On this subject, we must revert to the criminal code rather than the rules. Section 752 governs this situation. If the appellant is in jail, he remains there unless he applies successfully to an appeal court judge for bail. The criteria for release is not the same as in the Bail Reform Act provisions. Indeed, there is no legislative criteria. Certainly, there is no reverse onus. In Regina versus Simpson, a 1978 case, and it's found in 44 Canadian Criminal Cases, 2nd, 109, a county court decision of this province, it is suggested that in the absence of any criteria, regard should be had, by analogy, to Section 608 of the Code, which deals with bail on appeal before the Ontario Court of Appeal in indictable matters. Now, while that's very persuasive advice, I personally do not feel bound by that case. I think very simple criteria ought to be used, and perhaps this is an adequate summary of them. On the face of it, is there a legitimate ground of appeal? Is the appellant, if released, likely to appear, either personally or by counsel, to prosecute the appeal? Has the appellant been sentenced to such a short term that, if not released, the appeal will serve no purpose? And finally, what are the appellant's roots in the community? Of course, if the Crown is the appellant, these considerations do not arise. But if a private prosecutor is the appellant, not the Crown, a private prosecutor, then we run into Section 752.1. And when you've read it, that private prosecutor must undergo a, quote, security for appearance hearing before a justice in the presence of the respondent or his counsel, which implies service of a notice of hearing personally and a conducted hearing. Now, while this rarely occurs, and I'm unaware of any decisions on the subject, I can certainly conceive of a total failure to the appellant of the appeal itself if the justice decides on security terms unacceptable to the appellant. And in this context, a judge of the original trial court is the arbiter of the private prosecutor's security. One would have thought that if a citizen appellant must go to the county court judge for a release decision, then so should the private prosecutor for a decision regarding his security. But that's not the law. What does counsel require to put before a court to obtain bail? Well, at the very least, a copy of the information, an affidavit by someone who can say what the result was of the trial and where it was held and the details of that trial, an affidavit setting out the background and roots of the appellant, and very often those two affidavits are combined, proof of notice of the bail hearing upon the respondent in service of the affidavits, a copy of the notice of appeal, and a copy of the trial reporter's certificate. Always bear in mind, although it's rarely exercised, that there is a common law right to cross-examine on an affidavit. And again, while rare, it must be borne in mind that an application by an opponent in these proceedings to adjourn the bail hearing so that he could effect a cross-examination must be considered, and I would say to you that a judge or a justice would have to refuse an adjournment application upon judicial grounds. Well, let's go back to the rules now. Rule 6 provides that the hearing of the appeal is ready to be set down as soon as certain events have occurred. This rule incorporates Section 755, subsection 4 into its terms, and I must say to you that's an important reference. I'll not repeat the provisions here, but basically it refers to an application before the appellate court judge for a trial de novo. Now, one of the most common misapprehensions in this part of the law is that the appellant is entitled to start anew and relitigate his case. That would be not among lawyers, but among unrepresented appellants. In 1977, a law regarding summary conviction appeals underwent this abrupt change that I have been talking about. And so instead of an automatic new trial, the new legislation provided that a trial de novo would not be held unless there was an application, and the new legislation assumes that a summary conviction appeal will be determined on the transcript of evidence, much like an appeal in the Court of Appeal from an appeal against an indictable offense or conviction. Substantial reasons, and I put it to you most seriously, must prevail before a trial de novo should be allowed. There is also a provision for the adducing of new evidence, and I say to you again, substantial reasons must be present before that will be allowed. It is not a right, it is an exception. And I say this because after 4 years of the change of law that I have just spoken of, I am faced with many ignorant applications for trial de novo which rest on the assumption that the appellant will be given a new trial or a trial de novo simply upon application. Finally, my object tonight was not to teach or to research the law. Perhaps you are disappointed for that reason, but that was not my object. My object was to make you think, and I have taken two telescopes, one from the judicial bench of the appellate court and looked at these rules, and one from the point of view of the appellate citizen. I suggest that some reforms are in order and urgently, but I do not suggest their content. I cannot. But do not lose heart, for if the law is a lass, it's still pulling the cart.